I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive.
Good evening, ladies and gentlemen, degenerate sleuths of the night. We gather to boldly go where others have refused. Welcome to the DT show, you salty mofos.
A man accused of killing 4 college students is behind bars, and he has ties to northeastern and central Pennsylvania. State police say 28-year-old Bryan Kohberger was arrested this morning at a home in Chestnut Hill Township.
I can't find any case law that would support that idea. That somehow a warrant would be needed for DNA left at a crime scene.
We are expecting to learn more about the allegations against the girlfriend of a Boston police officer who was found unresponsive in the snow Saturday morning. I-Team sources say Karen Reed was in a relationship with John O'Keefe. She's facing charges including motor vehicle homicide and manslaughter.
So, the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So, get your popcorn ready and your choice of drink. Get your butt on your seat. Like, comment, and subscribe for a treat. Here we go. It's time for the show. The Drunk Turkey Show.
What's up, everybody? Welcome back to the show. Please hit the like button. Please hit the subscribe button. Ring that notification bell button. You guys know what to do. We got a great show, a surprise show I was not anticipating coming on tonight. However, some documents dropped. Last night, I had former FBI agent Jennifer Coffindaffer on the show, and she broke the news to me that there was a document of a notice of continuance. And she speculated that she thought it might be the actual trial itself. I know a lot of us were speculating whether it would be certain aspects of pertaining to certain motions, such as alternative perpetrators and things of that nature. Well, it seems like Miss Coffindaffer was more accurate than many of us, and rightfully so. I mean, she's been in the business for quite some time, so I'm not surprised. Before we get started, though, I want to remind you guys of our partnership with DataSeal. If you have any concerns or questions with your privacy, whether it be your name, phone number, address, religious preference, voting preference, those type of things, check out our partner with DataSeal. Links in the description. You get a 5% discount. What they do is they go out there and scrub all that information off the interwebs. Go ahead and search yourself, and you'll see what kind of stuff you'll find, and then maybe perhaps you'll be interested in the DataSeal. Also, I want to take this time to thank all of our mods. Man, you guys have been doing a tremendous job. Heather helps me out backstage, starring comments. Chloe's been helping me out with timestamps and also being my legal advice person that I go to, and Steelers fan and Sirius and Midwest and Mountain Mama and everybody else. I know I'm forgetting a few of you guys, and I completely apologize if I am, but I just wanted Extreme Blonde. Thank you. She just popped in. I want to say thank you guys for being here and really helping out with the channel and getting this platform where we're almost at. I mean, where we've been, and we're almost to 50,000 guys, and I wouldn't get anywhere near close to this without you guys. So I want to thank you guys. All righty. So with that being said, let's break it down. Let's get into the content. Let's share the screen here. Okay. Now, the first thing that we're going to look at is you have the defendant's motion to leave for leave to exceed the page limit. And then there's also an order granting the leave to exceed the page limit. This is that motion. Comes now, Bryan Kohberger hereby requests the court to order allow the defense team to exceed the page limit for the motion to continue for their ex parte supplement to the motion to continue. This motion is pursuant to Rule 82. So this is referencing the document that we're about to digest and go over, which is the motion to continue. It is Bryan Kohberger's team asking for from the judge to continue the trial, to basically delay it even more than it's already been delayed. Now, I will say this. I know a lot of people are pointing at the Dateline and saying, oh, the Dateline is what caused this. That is 0% true. This was going to be filed with the Dateline or the book that they reference in this article or in this document reference. This was already going to be filed, and Taylor had made comments about the amount of evidence and disclosure and discovery that they were going to need to go through, et cetera, et cetera. So these were all things that were already going to be argued against. And to be 110% honest with you, Judge Hippler has already, in my opinion, kind of squashed a lot of these. When it came to the sheer amount of evidence, the judge asked and stated, you didn't ask for additional help. You didn't ask for more paralegals. You said this. You said it'd take you 1 billion years or 100 years, several decades, et cetera, et cetera. And in the end, what he said, was basically he was shooting it down. And I think for the most part, I think that's what's going to happen with this. But let's go through it. We'll break it down piece by piece, and we'll talk about it. All righty. So motion to continue comes now. Bryan Kohberger, who hereby and respectfully submits the following motion to continue due to substantial amount of trial, investigation, and preparation still outstanding, as well as recent and forthcoming publicity that is high prejudicial to the defense. And obviously, this is the Dateline show that premiered, I think it was May 9th. And we're going to talk about the stuff that's in there. And does it really make a difference? All right, but let's continue. That's the last part of this document. As I said, this document was going to be filed before the Dateline premiered. They just added the Dateline to this as another reasoning behind for a delay. But there is some good stuff in here. I'll be honest with you. They talk about some red flags with Bryan Kohberger. And so it kind of gives you an idea of maybe perhaps, what they might be trying to do later on in court proceedings. So here's the argument. This is argument one. The court has the obligation to uphold Kohberger's constitutional right by vacating the trial date because the defense counsel needs additional time to review discovery and prepare for complex merits and sentence phases unique to the death penalty case. So first and foremost, just when it comes to the sheer amount of discovery, like I said, Judge Hippler's already shot that down in trial. He's talked about the things that Ann Taylor hasn't done. Let's continue this. The court has an obligation to enforce the constitutional right of all persons, including prisoners. As detailed in this motion, moving forward with the capital trial in August will infringe upon Mr. Kohberger's constitutional right as counsel requires more time to review discovery, complete investigations, and prepare for trial. When considering the request for continuance, the court must weigh the issues against the heightened need for reliability in the death penalty case. And a lot of these things, again, the defense has asked for. They said that there was, and they've already been denied. Like, for instance, the sheer amount of discovery. They asked for the death penalty to be removed because of it. They cited Lori Vallow and said that, there was a tremendous amount of evidence in that case. And the judge said, well, those are some different circumstances, and that those circumstances do not exist in the Bryan Kohberger case. And he's already denied these things. Yet here we are again. They're swinging the bat one more time to try to get now a motion to delay the trial. And they will say in here, that they've tried to say, all right, well, because of the sheer amount of stuff that we have to do, we've asked to remove the death penalty aspect of it. So that would remove some of the work that they have to do in preparation of the guilt phase portion of the trial. And like I said, that fell flat. I doubt this is going to move any needle forward, to be 110% honest with you. All right. As detailed in this motion, moving forward with the capital case trial in August will infringe upon Kohberger's constitutional rights. All right, we already went through that. Okay, with the defendant's life stake, the trial court must be particularly sensitive to ensure that every safeguard is observed. And basically what this is saying is that because this is a death penalty case, that this requires more attention than anything else, because this is the ultimate, the ultimate punishment for somebody when they commit a crime. And, I understand that and I get that. However, I think there needs to be an understanding that doesn't mean just because this is a death penalty case that it automatically should take 5 to 10 years just to get the prosecution side going. I mean, there's certain things that need to happen. He's already complained about memory of some of the witnesses. Well, prolonging this even further would perhaps infringe on the memory aspect of the reliability aspect of that. And obviously that's a tactic that the defense wants. But I'm fairly positive Judge Hippler sees past this. All right, number 2, Mr. Kohberger has a myriad constitutional right during the proceedings, all of which are dependent on counsel and having the time and resources to prepare for capital trial in accordance to establish professional norms. In a capital case, the rights to effective assistance of counsel and a complete defense are amplified. Obviously, that's true. And again, hold on, I want to make sure my audio is good. All right, everything looks good on my end. All right. Obviously, this is true. But at the same time, as mentioned in trial and in court, much of the evidence and the stuff that's in there in the discovery is stuff that's useless and baseless. It's footage from hours where there's no interest in those hours. They've been screwed through and there's no exculpatory evidence or anything like that. All that information has been given to the defense. They can go through it if they'd like. And I'm sure they have. I mean, you don't have to watch something at regular speed, especially if you're looking out for, I don't know, vehicles in certain areas at certain times. You can just fast forward until you see a vehicle pop into your screen and then you can slow it down, etc. So it's not a hard thing to do. But a lot of it is meaningless footage that they have compiled. However, as the judge said, you ask for everything under the sun. You can't complain about the weight of the planets. And this is what that was referring to. They asked for all the discovery in this case. And now you can't complain that, there's too much of it when most of it is not pertinent to the case at all. All right, let's continue. The Sixth Amendment entitles Mr. Kohberger to the effective assistance of counsel both at the merits and penalty phase of this capital case. Kohberger is entitled to a sufficient amount of time to allow counsel to adequately prepare for trial and sentencing, which, I think that the defense or the state had argued in one of their other documents, and even I think the court had mentioned this actually. I think it was in a court document that Bryan Kohberger's arrest was fairly quickly after the murders, right? It was 6.5 weeks after the murders. And in that time, up until December 19th, Moscow Police Department didn't even know who Bryan Kohberger was. And so the only thing that they had in their arsenals or in their ability to go through and look at were the tremendous amount of tips that came in. That's one. And two, the crime scene itself and perhaps some of the phone data of the persons who were in and around the area. Remember that phone dump that they took of like 3,800 phones or whatnot from the tower? Those things, right? So up until that point, they'd been investigating other people. They cleared a lot of other people. You can't clear somebody without an investigation. All right. So they investigated them. Those don't take a couple of minutes. Now, I understand that to the outside world, some of them may have seemed pretty quick because some people were cleared within a couple of days. However, if somebody has a solid alibi that's backed up and things like that, that they cannot be the person that committed the crime, it's not hard to clear someone. It's Bryan Kohberger who can't, account for where he was or anything like that. And his phone was off and et cetera, et cetera. And so, yeah, it is what it is. All right, let's continue this. In addition to the effective assistance of counsel, Mr. Kohberger has the right to a meaningful opportunity to present a complete defense. Well, they've had, that's where I was at. I apologize. I knew they've only really had 10 extra days, from the time that they got Bryan Kohberger's name and the time they have arrested him to build the case against him. So it's not like this huge ordeal where, the prosecution has had this X amount of time, much longer than the defense has had. It's nowhere near the case. And so, it's, if Ann Taylor was concerned about the sheer amount of work that she's got to do, one, she could have hired other paralegals, and two, she didn't have to take on a second death penalty case. Those are two things that she has done that go right opposite of what she is indicating in this documents of some of her issues. So the right takes on a special significance in a capital case. The right to present a meaningful defense must take precedent over any countervailing state evidentiary rules or procedures that must be acceptable in the context of a non-capital criminal cases. And there's a lot of fluff in here. There's a lot of fat in this document. It really didn't need to be as large as it is. However, they just kind of wanted to compile a bunch of stuff in here. And, I'll point it out. There are some times where they're explaining something and I'm like, well, the judge knows that. But we'll get to it. B, Mr. Kohberger is also entitled to an individualized sentencing determination and a constitutional right that is uniquely reserved for the defendants facing the death penalty. Because the prosecution is seeking to execute him, Mr. Kohberger also has additional constitutional rights in this proceeding. The Eighth Amendment requires that the capital sentencing proceeding permit individual considering the defendant and the circumstances of the offense. The U.S. Supreme Court has repeatedly emphasized that in a capital case, a jury must be given the opportunity to consider all the evidence that may weigh against the death sentence for a particular order. The evidence includes anything at all from the defendant's life history and cannot be limited. So they want to basically go into Bryan Kohberger's life history. They want to look at not just his entire life, but his parents' entire life, his grandparents' entire life as well. So they want to go, they say 3 generations back. So I don't know if they consider Kohberger as the first generation that they want to go through, then parents and grandparents, or if it's parents, grandparents, and great-grandparents. But they want to go through everybody's history to try to explain why this could have happened if he's found guilty. And they want to be given the opportunity to do these life investigations on all these individuals. And I mean, I don't even know if some of these folks are alive still. And I don't know how much or how long it would take just to sit down with these people, maybe a day or two. Like you find them, coordinate it, sit down with them, go over the medical history, go over, a bunch of other things, just have a very intense and, interview with these folks to get the information that you need. I don't think it's something that requires months per person either. So let's continue this though, because it's interesting about what are these life events. They talk about red flags, and I want you guys to remember what red flags they're talking about, because they bring up some red flags, and this could be like a clue, so to speak, of what the defense is trying to say as to why Bryan Kohberger may have committed this crime if he's found guilty. They're not saying that he's found guilty, that they're going to present a why, obviously, but they want to go further into it as far as trying to say, like, for instance, that maybe perhaps he was malnourished, or he had his mother drank or did drugs while she was pregnant with him, those type of things to answer the why aspect. It's weird, but it is something that they have to do. All right. Vacating. So they go into a couple of examples of why the death sentence was vacated. So finding it was constitutional error. So in Eddings versus Oklahoma, finding that it was constitutional error for sentencing court to conclude that it could not consider the defendant's turbulent family history and mitigating factor in deciding punishment. So these are some of the cases that they're going to be pushing towards, and there's got to be some sort of resemblance to this case. So is Bryan Kohberger trying to say that he had a turbulent family history by using this Eddings versus Oklahoma? And all indications and everything that I've heard was that his parents were good people. You know what I mean? And his parents were in the school district and were good folks, but he's citing this as a mitigation factor so that he, is a potential reason for not to get the death penalty, or a reasoning to present to the jury and or the judge when it comes to the penalty phase aspect. They want them to take this into consideration, the fact that he maybe had a turbulent family history. Let's continue. Henry versus Lanaw, vacating the death sentence because the trial's court instruction to the jury did not allow the jury to consider the mitigating factor evidence of the defendant's mental retardation and childhood abuse. Now we know that the defense has indicated that Bryan Kohberger has ASD or autism, but they've also indicated that he has an IQ of about 119. So I mean, what are they trying to say with the mental retardation aspect of it? And then childhood abuse. Are they going to that Bryan Kohberger was abused by his parents or something? I mean, I don't understand this. So let's continue. Finding that Texas 3-question sentence format in light of a jury instruction, all of the circumstances of the case did not adequately allow the jury to consider mitigating evidence of mental retardation. So here it comes again that they're citing another case, Penry versus Johnson. This is a Texas case, and that the jury wasn't able to consider evidence of mental retardation. So we've seen now two cases that they have cited where mental retardation is a reasoning behind the death sentences being overturned or changed to a life sentence or of some sort. And so is Bryan Kohberger trying to say that with his ASD? Is he trying to use autism and blur the lines there? Well, I think he's blurring the wrong lines. And this is definitely a losing argument, in my opinion. Definitely a losing argument. All right, so let's go to C. Right to the qualified expert assistance is part of the guarantees to effective assistance of counsel in an individualized sentence proceeding. In line with heightened protections afforded to capital defendants and stemming from both rights to a meaningful opportunity to present complete defenses, capital defendants are entitled to necessary expert assistance. And I think they've gotten that. They've had their access to experts. I think they even have a lawyer, Barlow, I want to say, who's also an expert in forensic genealogy and DNA stuff. So they've had access and to it. Maybe perhaps they're having problems finding experts that will align with their narrative. Maybe their narrative is wrong. Just throwing that out there. Let's continue. Analyzing and interpreting such evidence is impossible without consulting experts, whether pathologist, serologist, microanalyst, DNA analyst, ballistic specialist, translators, or others per the ABA guidelines. However, in the case where prosecution elects to seek the death penalty, the right to access competent expert assistance is particularly important given the prosecution and the defense rely more extensively on experts in death penalty cases than in other type of criminal cases. Because prosecutors rely extensively on experts in death penalty cases, capital defendants cannot present their claims fairly with the adversary system if they have not also obtained a competent expert assistance. So what is he trying to say? Is he saying that they're having problems finding experts? Maybe perhaps the whole Syray thing blew up in their face and well, maybe their experts don't want to work with them now. I don't know. I don't know what this means or what, but it seems like they're having a problem with experts to be throwing this as a reason to delay this trial. All right, let's continue. So beyond frequent complex merits phases issues, conducting an adequate investigation into the sentencing phase issues a capital case almost requires the assistance of multiple experts. And then they show McWilliams versus Dunnan, explaining that when a capital defendant's mental condition is seriously in question and is relevant to the punishment might suffer, the state must provide a mental health professional capable of conducting an appropriate examination and assisting in evaluation, preparation, and presentation of the defense, which I thought they got that. Didn't they get a doctor to evaluate him, and they said that he had ASD? They even objected to the state's impartial doctor of going in there and speaking with him to a certain extent. That's already been filed and gone through. It's been approved, and I'm assuming it's happened already, where the state has had somebody, a doctor, go in there and speak with Bryan Kohberger. But again, mental condition is seriously in question. I don't think his mental condition is seriously in question. He was a PhD student in criminology. He wasn't a student of agriculture. He wasn't a student of geometry, math, science, whatever. It was criminology, right? And not only was he a student of criminology, but he had a master's degree. So he literally mastered the subject of criminology, which is the law, what's legal, what's not legal, right and wrong. So he understood those things. He had an IQ of 119, and so he wasn't stupid per se. He was intelligent enough to get a 119 and master a criminal justice program, right? I mean, if there's anybody else who would have known the difference between right and wrong, it should have been him. Even if he doesn't have feelings, even if he can't feel, sadness or he can't feel remorse or any of those things, that doesn't mean you don't know the difference between right and wrong. And he studied the subject of what's right and wrong, and he mastered it with a master's degree. So I don't understand this mental condition is seriously in question here. Maybe the defense team mental condition should be in question here with what they're trying to say. Let's see. Noting that because mental health issues pervade capital cases, a psychologist or other mental health expert may well be a needed member of the defense team. So they want a doctor on the defense team. An additional expert assistance specific to the case will almost always be necessary for an effective defense. I'm not opposed to him getting a doctor, to talk to him or whatever the case may be. Maybe he'll confess. I don't know. I don't know if that would ever be, used against them or anything like that. But, what I am against is the fact that they think that all this can prolong the trial. So far, a lot of what they've said has been presented in court already, and Judge Hippler's already squashed it. So I see it the same with much of this. As discussed further below, defense counsel cannot know the full range of experts that may be necessary until after the extensive social history investigation has been completed. So they're asking for a full list of experts, but they don't even know what experts they need. They need to do a bunch of work first. And so they're probably wanting this to be pushed, not even next year, but the year after that. Both the identification of mental health professionals' necessary area of expertise and the accuracy of the expert's diagnosis is dependent on having accurate and comprehensive social history information. Counsel professional and ethical obligations in a capital case. Counsel's duty to provide effective assistance on counsel in accordance with the prevailing professional norms. In order to effectuate Mr. Kohberger's constitutional right, as described above, counsel must meet the minimum professional obligations for counsel on a capital case as outlined in the ABA guidelines. The ABA guidelines require a high quality legal representation for all persons facing possible imposition for execution of death sentence by any jurisdiction. So basically just kind of saying that they need a robust defense team and things of that nature, because the ultimate punishment is going to be enforced if found guilty. And they want to make sure that they get this robust team, which I think they've had a pretty robust, he's had a pretty robust defense team. And I think that's what, I want to say it was Hitler. It could have been Judge, but I'm pretty sure it was Hitler who mentioned that, saying he's had a robust defense, much more than like what most get, to be honest with you. The minimum requirements counsel must meet in investigating for the merits phase of a capital case. Respect to the investigation for the merits phase, the ABA guidelines are clear that counsel must thoroughly investigate and challenge every minute piece of evidence the state purports to have. So they've been planning this for a while when they wanted all the evidence, even the stuff that didn't have anything to do with anything, right? They just wanted that thumb drive with all the video footage of things that and times that are even irrelevant and in locations that are irrelevant. But now they want every minute in piece, and they want to thoroughly investigate every minute piece of evidence. Yeah, they want to go through it with it, like, come on now, man. Come on, no. And the judge has already said, what this is going to take you, what, a million years, 100 years, several decades? No. So it goes on to say, the defense lawyer's obligation includes not only finding, interviewing, and scrutinizing the backgrounds of potential prosecution witness, but also searching for other potential witnesses who might challenge the prosecution's version of events and subjecting all forensic evidence to rigorous independent scrutiny. Yeah. And that's why you've had about 3 years to do this. It's not like Bryan Kohberger got arrested last week, guys. C, counsel must conduct an exhaustive, unparalleled life history investigation, analyze hundreds of documents and interviews, and compile all of this information into a cohesive narrative for the sentencing phase. Again, this is something that she knew about for a while. You know, these are things that they've known that they've had to do for years. They knew this was a death penalty case for a long time. This isn't no surprise. There's no gotcha in any of this. None of it. It says here, 1, a constitutionally adequate investigation entails a constitutionally adequate investigation for the sentencing phase of a capital case requires a comprehensive investigation into the client's entire life history in order to present a complete picture of the client's mitigating life circumstances to the jury. Compiling a comprehensive life history for a capital sentencing phase requires 2 primary responsibilities, which are dependent upon each other, as further explained below. These responsibilities are: 1, collecting and analyzing records from the client and the client's family life history, and 2, interviewing individuals who have touched the client's life or who have been able to shed light on circumstances shaping the client's life. So these are the following things they want to go through: medical history, complete prenatal, pediatric, and adult health information, exposure to harmful substance in utero and environment, substance abuse history, mental health history, history of maltreatment and neglect, trauma history, educational history, employment and training history, military experience, multi-generational family history, genetic disorders and vulnerabilities, as well as multi-generational patterns of behavior, prior adult and juvenile correctional experience, religious, gender, sexual orientation, ethnic, racial, cultural, and community influences, socioeconomic, historical, and political factors. All of these things that they want to go through with Bryan Kohberger, which again, these are all things that they would have known for years at this point. So to me, all they're doing is just kind of compiling all these things out and listing them out to try to make it seem like, oh my God, this is so much work we have to do. Yeah, the judge knows about all this work. You know, I'm pretty sure he's familiar with the process of what happens and what you need to get. And so, to me, it sounds like a lot of whining and complaining, like, oh my God, I have so much work to do and I can't do it all. But all this has already been shot down already. All of it. All right, so let's see. The defense team must identify, locate, and interview life history witnesses in a culturally competent manner in order to produce confident, relevant, and reliable information. Late witnesses must be interviewed, include people such as the client's family, extended to 3 generations back, and those familiar with the client's friends, teachers, classmates, coworkers, employers, served in the military with the client, a bunch of other people, training history. Like, one, he wasn't well liked, so he didn't have very many friends. Most people don't. It's the truth. He wasn't well liked. I think I found all his friends that he's ever had, and we interviewed most of them on the show. I think Bree was like half of them, and I think he had another one who invited him to a party, and they were interviewed on Dateline and such and such. So, yeah, it shouldn't be that hard. He didn't have very many jobs either. He got fired from most of them too, oddly enough. But these are all the people that they wanted to go through just to kind of fluff everything, show how much work they have to do. It's nothing different than anybody else needing to going through this. So they bring up other court documents, right? And here I find it interesting. It says here, records indicating that the client's mother drank alcohol during her early. Now, this isn't saying that Bryan Kohberger's mom did. This is an example. It says here, mitigation investigations develop in stages. As explained in this example, records indicated that the client's mother drank alcohol during her early teenage years and would lead to the mitigation specialist to question the mother, her family, or friends regarding their history of alcohol use, particularly whether she drank during the pregnancy. So, again, kind of going back to some of the things that they've been pointing out, as far as they want to say that if found guilty, the why is some troublesome stuff in his childhood and maybe perhaps leading all the way back to prenatal issues. Unsurprisingly, the process takes time, especially because many witnesses must be interviewed multiple times, even after rapport has been established. But does it really? I mean, it's not like, all right, you're interviewing his friends and his family. I understand maybe perhaps people who might be not wanting to help Bryan Kohberger, not wanting to be a part of the defense team, such as like victims' family members or the surviving victims. Those, like Bethany, the defense try to pull in. But Bryan Kohberger's mom, dad, sisters, friends, stuff like that. I mean, you gotta interrogate them to get good stuff out of them. You get what I'm saying? It sounds weird, right? Like, I don't know. Adding to the complexity, has long been recognized that a component of mitigation investigation must include the family history going back 3 generations. And they highlight this, and they want to talk about how they need to interview all these individuals and must document genetic history, patterns, and effects of familial medical conditions. Oh, geez. I saw something and I was like, wait a minute, what? It says Daniel J right there. But it's not me, guys. It's not me. I have nothing to do with his medical history. All right, let's see. A full investigation is likely to lead to the discovery of numerous mitigation factors that would not be readily apparent from a cursory investigation. Basically saying that by doing all this stuff, by digging into his background, you're going to find these red flags in Bryan Kohberger's life. And they kind of just go over and over again. Like all this stuff that I'm kind of just fast forwarding through is just talking about, all right, if we look at his juvenile and adult criminal history, including influences, co-defendants, experiences with law enforcement, military history, employment history, number of traumatic events, death, illness of injured loved ones. I mean, it's just a bunch of the same stuff over and over again as far as what they need to investigate for. And they go on here to say mere identification and mitigation information is not the conclusion of the investigation. So even if they find things, that's not the end of it. They still need to do more. And then they give an example. It says, for example, childhood poverty. So we've known that Bryan Kohberger, his parents didn't come from money. He didn't come from money, right? One of the things that they say that is reasons his folks aren't in courts because the cost to travel cross country. So now they're going into poverty. They talked They brought up some cases about, childhood trauma and issues. Now they're bringing up poverty. So childhood poverty is a common mitigation theme in capital cases. Simply knowing that the client's family was very poor is insufficient. Social science has extensively documented how poverty can snowball into major problems. Yeah, but I mean, the problems that you get out of poverty that result into some like major problems are like gang related, and then turn into violent gang crimes and stuff like that. You have somebody in poverty, they end up, searching for outlets for financial gain, whether it's drugs or whatever, sex, whatnot, and then that just kind of snowballs into a bunch of other stuff. I'm not necessarily certain poverty turns people into serial type offenders, to serial killer type folk. You know what I'm saying? So, again, they're using what maybe perhaps some other people use as an excuse as far as why they joined the gang life, why they were involved in robberies and criminal theft and things of that nature. And again, throwing his own parents under the bus. I mean, bringing up, in my opinion, he's throwing his own folks and his family under the bus, taking a page out of Casey Anthony's playbook, in my opinion. Wouldn't be surprised if we end up hearing some more weird stuff out of this. All right, let's continue this. Social science has extensively documented how poverty can snowball into major problems such as increased likelihood of physical and psychological abuse, antisocial behaviors, long-lasting psychological effects such as depression, poor impulse control, high levels of dependency, increased likelihood of diagnosable psychiatric conditions, increased likelihood of trauma, which can result into serious long-term consequences, both physically and psychologically. So now, because his parents were poor, there's a reason why Bryan Kohberger may have committed this crime. I think this is just ridiculous, guys, to be honest with you. The contextualization and the integration of mitigating life history information is an essential part of the capital sentencing decision because jurors ultimately are looking for an answer to the question why. So this is what I said before. They're trying to explain the answer of why did Bryan Kohberger commit this crime if found guilty. Now they're going to go on and say, well, we're not saying he's guilty or any of those things, but this could answer the question why. Why did he decide to go in there and commit a crime like this? So long-term consequences of poverty can be empirically documented. The documentation can serve as a solid factual scientific basis for the penalty phase continuation that a childhood poverty over which virtually no capital defendant has any control helped shape his life course, drastically limited to available choices, and contributed directly to the criminal behavior and lifestyle in which he engaged. So they're saying because he grew up poor, that contributed directly to the criminal behavior and lifestyle which he engaged. Jesus. My gosh. This is stupid. I'm sorry, but this is stupid. D, the alleged aggravating circumstance in this crime heightened counsel's obligation to conduct a full and complete investigation and prepare a presentation that can withstand adversarial testing. It should be noted that an integrated, comprehensive life history is not a luxury to be afforded to only some capital defendants, nor is it offered as an excuse that stands no chance in the face of aggravated crime. Rather, it is a vehicle that confronts the challenges of the stereotypes of the natural-born killer, offering instead an examination of the structure of the lives of those who commit capital offenses or violence. Basically saying, well, this is the reason why. There's no such thing as a natural-born killer. He wasn't born this way. He had things happen. Trauma in his childhood. Maybe his mom drank. They grew up poor. All of this are reasons why he lost it, and he ended up killing 4 people. I think it's incredibly weak, just like most of this motion. To be honest with you, it's my opinion on this. All right, I'm going to answer a few questions real quick. I know we got a few live and super chats. Let me answer that before we go forward. We have Merville coming in with a newest member. Thank you. We got Christy, newest member. Thank you. We have Lady Stardust 2008. Thank you so much. And I'm going to go through some questions at the end as well, guys. Trial needs to happen soon. I'm not getting any younger. Thank you, Mountain Mama. Shelly says, this is a strategic move to set up for an appellate court after conviction, in my opinion. Maybe. I mean, I think it was going to happen regardless. And they're gonna make appeals. There's going to be files for appeals after he's found guilty, and it doesn't matter, you know. Everybody has the right to file an appeal. Don't mean he's going to win anything either. The defense strategy can work against him too. Can explain no empathy as to why he can commit this crime. 100%. That's a good point there. 100%. Natalie James, is Ann Taylor able to challenge the death penalty during pretrial hearings an unlimited amount of times? Seems as soon as she needs to bring her alternative suspect, she repeats the same stall tactics. Good point. Good point. I don't know if they can do it as, you know, just as, you know, random times like that. That's a good point. I don't know. Thank you, Amanda, for becoming the newest member. We also have Midwest dropping in with a gifted Drunk Turkey Show membership. Thank you so much. I love tacos with a $9.99 super sticker. Thank you so much. All righty, guys. Let's get back into this. And when will we find out if there's a delay? I'm not sure. You know, as soon as I find out, I'll let you guys know. That's for sure. There are many examples of capital cases in which the presentation of comprehensive life history and mitigating circumstances overcame aggravated crimes, including cases with multiple victims. Juries have rejected the death penalty in at least 400 cases involving multiple victims. So I know I saw a question or a comment earlier where it says, you know, I live in Idaho. If not this case for the death penalty, then what case? Well, here they're going to try to bring up other cases that were pretty severe, and yet the death penalty wasn't brought in, and they're going to try to use that as a reason why Bryan Kohberger should not face the death penalty. So they talk about, for example, Ricky Abuta killed a state police officer, sheriff deputy, his girlfriend, along with her 18-year-old daughter and adult sister, another teenager, and a 6-month baby in a small New Mexico town of 2,500 residents. A jury sentenced him to life after deliberating for 11 days. Now, what I don't know about, you know, in this case is the family's feelings about the death penalty in any of these cases. You know, is that something maybe they were opposed to? I don't know. I don't know anything about these cases, but I agree that probably should have seen the death penalty too. Jason Burkett, a co-defendant, killed 3 people, including a 16 and an 18-year-old in 2 separate episodes. A Texas jury sentenced him to life. Now, what was the surrounding situations behind that? I probably should have looked that up. You know, was that something? And I don't know anything about that situation, but they took the lives of 3 people and 2 separate issues and didn't get the death penalty. Andre Cooper was a gang leader convicted of killing 4 people, including eliminating a witness against him. A Pennsylvania jury rejected the death penalty, but Pennsylvania is pretty, I guess, liberal when it comes to those type of things. I don't really know. I don't know how Pennsylvania is about the death penalty. I think they're one of the states that are harder to get. You know, the one I would look at is like the Texas jury one, and I wonder if what was the situation behind it, you know. But they bring up some other instances as reasons why they shouldn't, or why Bryan Kohberger shouldn't receive the death penalty, and I don't think they're very good ones. Counsel cannot identify all necessary experts without completing the comprehensive life history investigation. So we went through a whole lot of files about why they need to complete the comprehensive life history, and they're going to go through it all over again, which is why there's not much highlighted. All right. Experts are often essential to telling their client's story in a way that answers all the important why questions. So here it is again, why. And so what they're trying to do, the only way that they can answer the why question is by doing this backstory on him, you know, checking his life history, criminal history report, whole 9 yards. So that way they can come up with a reason to tell the jury, like, all right, you know, he wasn't just born this way. He's not a natural born killer. He went through some stuff. He saw his mommy and daddy drink, and they weren't the wealthiest of folks. And so he turned into a psycho killer. I don't really see the correlation. I don't see the dots connected there, but I don't know. This goes on to say there are numerous examples of capital cases reversals because counsel failed to complete the social history investigation, even when competent experts have been hired, because the evaluation resulted in inaccurate or an incomplete information presented to the sentencer. So this is more of like a little shot, like, hey, all these cases have been reversed because this information didn't come through. We're going to try to do the same. Don't mean you win. You know what I'm saying? You can threaten all you want, but don't mean you're going to win. Counsel requires additional time to fulfill minimum requirements described above. Counsel cannot review all of the relevant discovery and complete the necessary investigations prior to trial. It says it is impossible for the defense team to review all the necessary and relevant discovery in the manner that allows the evidence to be integrated into the comprehensive defense case to pursue all necessary investigations arising for the review of discovery, including into alternative perpetrators. So they still haven't finished doing that. You know, they added it in there. It is they need all this stuff. It's still, you know, complete to it's relevant discovery and complete the necessary investigations prior to trial. And one of it is to include into alternate perpetrators. So they haven't finished that. They don't know. To me, these are like, hey, you know, we think he's innocent, so there should be something there. We just haven't found it. And, you know, not really taking into consideration this guy probably did do it. And the reason you're not finding these things is because they don't exist. All right, let's continue. And to address the myriad issues that continue to arise from the state's failure to fully abide by the court's discovery. Oh, like the whole calling advanced timing records that AT&T only keeps for 7 days. Like that discovery that you guys did like 50 motions to compel, that even Ann Taylor went into detail saying, you know, a lot of our work has been to get these advanced timing records from AT&T. We have put in a significant amount of work and effort into it, and we don't have it. You know, at the end of the day, these guys believed Cy Ray, and Cy Ray told them, oh, they should have it. They have it. And they didn't have it. And they believed them. And what these guys probably did is they probably like, well, we really don't have to work too hard on everything else because we haven't gotten the advanced timing records. We know they have them because they have them for 3,800 people. So we know they have Bryan Kohberger's, because why would they have 3,800 people but not Bryan Kohberger's? Not dawning on them that his phone was off. Because remember, it dawned on her during that hearing because the judge said, well, they didn't even know who he was. And she's like, that's right. They didn't, not at least until December 19th. And then it started to click. The wheels started to go in her brain. And she started to figure out why it is that the prosecution has been saying they didn't have it. But yet they're still using that as a reason why they need more time. Interesting. All right, so it says here, the counsel requested this court alleviate problems by precluding the death penalty as a possibility. Because the court denied that motion, counsel is obligated to seek a continuance to continue the reviewing discovery, complete investigation relating to the merits phase, including into alternate perpetrators again, and the complete investigations into red flags that have arisen in the life and history investigation. So right here, it says that they have found red flags that have arisen in his life and history investigation so far. So they found some red flags, whether it be the poverty, the mental retardation aspect that they spoke about earlier, which I think is they're trying to tie in his supposed autism into it. And some sort of childhood abuse, going back to possibly prenatal abuse. Maybe his mom was drinking while she was pregnant with him. I mean, who would have to come forth and say that, right? His mommy? You think his mommy came up and said, you know, in efforts to try to save his life, say, I drank while I carried him. He's this way because we didn't give him what he wanted because we were too broke, and we couldn't buy the toys he wanted for Christmas. We couldn't give him the attention that he wanted because we had to go to work. There's some sort of family abuse there because of that. Is that the route that we think she's going? You know what I'm saying? But they've admitted there's red flags there. There are some red flags, and they're prepared to answer the question why Bryan Kohberger did this if found guilty. Prosecution has not provided the defense counsel with a list of potentially exculpatory or impeaching evidence with the vast branches of discovery. In this case, the court declined to order them to do so. No, that's bullcrap. That court asked them if they had any exculpatory evidence. That's pretty much a demand there. That's demanding information. Do you have it? They said no. It doesn't exist. Again, this goes back to how many motions to compel for the Bryan Kohberger advanced timing records. That was your mistake, lady. That wasn't the state's. That was your fault that you believed this guy who was thrown out of what they say his stuff was junk science, and now his stuff is called a conspiracy theory by another judge. Yeah, good luck, buddy. Good luck. The state's case is circumstantial. From your point of view, Mr. Kohberger was not identified as a person of interest until weeks after the crime. And after he was identified, law enforcement ceased investigating all other possibilities. Well, it's because he started to fit the bill. Like, where is it in the law book? Does it say that once you once you follow the evidence and it starts to point at somebody, that you have to not follow the evidence and investigate others? Make up things so you can investigate others. Violate other people's rights and freedoms just so you can say that you investigated others. This is stupid. In fact, we know they investigated others. There was a lot of people that were investigated, and including, remember that secret surreptitious cigarette butt thing that they took for DNA? That guy ended up getting cleared on. Well, they investigated others. It's just once they found and landed on Bryan Kohberger, they're like, all right, we got this guy. Does he drive a white Elantra? Boom. Did he have a front license plate during the time of the offense? Boom. Was he out and about at that weird specific hour of the night? Boom, boom. You know what I'm saying? Like, it's all right. Well, his DNA is there. Let's look at his purchase history. Has he ever purchased a K-bar knife sheath and a K-bar? Boom, boom, boom. Like, I mean, just everything just compiling on this guy. So, why focus in on other people that you've cleared? Makes zero sense. So let's continue. While counsel has explained this in trial, every experienced trial lawyer knows that trials are essentially story battles, high-stakes duels where the prosecution and defense each tell compelling narratives about the same events. Not really. I think that the evidence speaks for itself. Obviously, the defense is going to want to, throw out a compelling narrative about the same events that the state is going to offer evidence to. But if you follow the evidence, it's pretty clear. It's not a narrative. Ultimately, the jury decides which story feels more true and coherent. Yeah. No, I think they figure out, is there any reason, any reasonable doubt there that this person didn't commit this crime? And if there isn't, and then, is guilty beyond proof of reasonable doubt, then it's different than feeling which story is more coherent and which one makes you feel better. It's, maybe some other cases you're looking for a story that makes you feel better, but this is the way the defense wants, because I've seen other cases act in a very similar manner. I have a saying that I've told some folks who have tried to tell me, like in another case where there's missing tail light pieces very early in the morning, and then somebody wants to tell me that, oh, but a witness said that they saw it later on in the day and it looked cracked, not missing, but there's pictures that I can see where it's missing, and I make the statement, like, for me to believe, like, the defense, it's almost like somebody pissing on your leg and telling you it's raining and you believe in it. It's kind of the same thing here. Like, all the stuff that kind of goes into play, and then the defense wants to come up with this story and narrative to convince you and say, hey, our narrative makes more sense. And what narrative can they be, right? They're going to want to try to say Bryan Kohberger has no criminal history, which, although he kind of does, he did get arrested, he got expunged. It is what it is. Yeah, with no criminal history, PhD student, no connection to these individuals as far as like a reason behind why he would have committed this crime. He wasn't involved with any of them romantically, wasn't friends with them, those type of things. And they're going to try to look at, all right, well, you have this other guy, and we'll use like Jack DeCore, and well, he's the ex-boyfriend, and they broke up, and he was with the victims the night of the murders, and they were contacting him in the early morning hours. And so they're going to be like, which story makes more sense? But once you start to look at the hard evidence, Bryan Kohberger's phone was off during the time of the crimes, not Jack's. There was a white car that was circling around, not somebody walking around because he lived so close. And the whole idea that she broke up with him was a reason for him to do that. The voicemails and text messages left on Jack's phone were Kaylee wanting to get back with him. So that completely blows up that narrative that he was upset because she left him. So again, they want you to believe this story and not look at the evidence behind it. Hope it makes sense. Hope that makes sense, guys. All right. As scholars explain, where the central issue is the identity of the perpetrator, even a reasonable doubt case implies a story that someone else did it, but it is a story with a huge hole and one likely to be ineffective. The jury might speculate that if the defendant did not do it, there should be at least some evidence suggesting someone else did it. And it especially incumbent on the counsel to become aware of all existing evidence, because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it merely tends to mislead the jury that another person committed this crime. So this is kind of an indication of where their proof is, right? Why would they be putting this up there if they felt like their proof of alternate perpetrators was strong? To put this in there to say, it is especially incumbent on the counsel to become aware of existing evidence because alternate perpetrator evidence may be deemed inadmissible under Idaho law if it merely tends to mislead the jury that another person committed this case or this crime. It also goes on to say that even a reasonable doubt case implies the story that if someone else did it, but this is a story with a huge hole, one likely to be ineffective. The jury might speculate if the defendant did not do it, there should be at least some evidence suggesting someone else did. So what the argument is that they have insufficient evidence, and if they aren't allowed to use that insufficient evidence, then the jury might be swayed to believe that because there's no evidence of somebody else could have done in this crime, that it's prejudicial against Bryan Kohberger somehow. It's just a stupid argument, guys. I'm not gonna lie, it is. A lot of these are, but again, when this is all you have, right? I think Howard Bloom said it best. When you're right, you pound the facts. When you're wrong, you pound the table. And this is what all that is. You know what I'm saying? They're not looking at any hard facts or evidence or any of those things. All right, let's continue. The state is superior investigatory apparatus has spent years honing in on one specific story, that Mr. Kohberger's guilt, and ignoring all the other possibilities. Well, that's not true, because we've talked, even in this podcast, I mentioned that they had referenced Bryan Kohberger, other suspects in this case. So we know for a fact that's bullcrap. We talked about the cigarette butt. Let's see. Defense has a bigger job, not only in reviewing their case for guilt, but figuring out what the state missed and exploring alternate possibilities. The inability to review the discovery and incorporate all the information into a cohesive defense prior to trial would nearly guarantee the counsel cannot amount to the effect defense on Mr. Kohberger's behalf. Let's see. The live history investigation ongoing requires additional time and expert assistance. As explained in the accompanying ex parte filing, the investigation to date has revealed red flags for a number of mitigating themes and issues. For counsel must fully investigate these avenues before making strategic decisions relating to sentencing. So they found red flags. Those red flags, again, poverty, childhood abuse, going back to prenatal while he was in the womb, drug abuse history, which we're aware of, those type of things, mental health issues. So they found some red flags, and these are the ones that they've been really compiling in on. Take that for what it is. Now we're at the Dateline, finally. So a recent Dateline NBC special and forthcoming book. So there's a book also coming out. On May 9, Dateline aired a 2-hour episode about this case titled The Terrible Night on King Road. The program indicated details of materials, including video footage, cell phone records, and photographs of documents that are not publicly available through official channels. The show emphasized on the non-public nature of this information, stating it was obtained from unnamed sources who are close to the investigation, that the materials were obtained exclusively by Dateline. Much of the investigative material presented by Dateline was taken out of context and will not be admissible at trial because of its lack of reliability. Leaked information material appear carefully to correlate and promote the narrative of guilt. As the court acknowledged, in the May 15, 2025 hearing, the source was a leak, most likely someone currently or formerly associated with law enforcement and prosecution team. That's the case, raises urgent and serious questions about the objectivity, judgment, and credibility of individuals tasked with the investigating and presenting the state's evidence, particularly those that may be witnesses. So they kind of go into some of the things that were included. It says the episode included things like repeated speculative assertions regarding the assailant's motives, including unfounded allegations of sexual motivation. Dramatic reenactments and animations depicted the alleged crime created by the show's producers without basis of evidentiary record or basis in the evidentiary record. Emotional interviews with individuals connected to the alleged victim, accompanied by evocative music, photos, videos designed to elicit strong emotional response. The broadcast repeatedly boasted speculative claims through the use of so-called expert commentary, including individuals identified as law enforcement professionals and academics. These commenters were permitted to make sweeping assertions about the defendant's alleged motives, psychological state, and personal history, none of which are grounded in evidence before the court. So, they're not saying it's not real. They're not saying it's not true. They're just saying it hasn't been presented before the court. So take that for what it is. They're not arguing that Dateline put any false information. They're arguing that Dateline put up information that may not be admissible because of its reliability and because some of the information has not been grounded in evidence before the court. Nothing here suggests that what Dateline put out there was false. That's the first thing that I read. Now, there's also going to be a book, which they're probably giving more publicity to this book. There's a Dateline special, which aired just weeks before the trial, will not even be the last media portrayal. Bombshell best-selling crime author James Patterson has written a book about the murders titled Idaho 4, an American Tragedy, scheduled for release on July 14, 2025. The blurb for the book describes Mr. Kohberger as a brilliant grad student loner, a parent incel, and explicitly tells the reader, now are the jury, the evidence is in. The publisher boasts of the unmatched access to the investigation, including interviews with local law enforcement. This suggests that an apparent Dateline leak was not only the only violation of the court's non-dissemination order. So let's actually break down real quick what it was that was in there. So we had the that he bought the knife and he bought the K-bar knife. That was in court documents that he bought it on Amazon, and even specified March 20th through March 30th, 2022. So that wasn't something new. 23 trips before the murders. That was also in a court document before the Dateline episode. That he searched for the K-bar knife after the murders. Also in court documents before the Dateline. That he searched Na-Young Co story. Now, the Na-Young Co story, the fact that she believed that Bryan Kohberger broke into his apartment. She's not part of the non-dissemination order. She's not gagged. Her situation that she believes Bryan Kohberger did has nothing to do with the Idaho murders. Nothing. So I don't think that and this goes for not just her, but this goes for Holly, the hiker, the DJ, PhDJ guy as well. Their interactions, they're not part of a gag order, and their interactions had nothing to do with the crime that occurred at 1122 King Road on November 13, 2022. So they're not part of the problems at WSU. That's been out for a while. The fact that he got fired, terminated, we've known about those things. We've known about the issues that he's had with his professor and other female students. That's not a surprise. The information of suspect vehicle 1, they dropped, and they, meaning the court, released screenshots of the video leaving at certain times. We have an account on the PCA of the vehicle leaving at certain times and entering that area at certain times. There's also audio that is played at 4:17 a.m. That audio is being described of what you hear in the PCA. So that has been out for a long time. To me, what is the difference between that and the transcript of the 911 call and then the 911 call getting released? All of those things have been explained and have been talked about in detail through the court. It's not anything special. All righty. So what did they show that we haven't seen? Well, there was photos of Bryan Kohberger's car before and after the murders, and before and after he went and got his license plate changed. We knew he changed his license plate, so it's not really a big thing, right? To me, at least. We find out about the calls to dad in the morning hours after the murders. I mean, I don't know. That doesn't really say that he committed a crime. I don't see how that's prejudice against him. Obviously, a lot of people are going to speculate, including myself, that he did that because he was wanting to gloat and just speak to anybody. But Dateline didn't say that. I did. They just said, hey, he called his dad. All right. Okay, so they went into details about Ethan's injuries to his legs and the fact that Bryan Kohberger allegedly sat down in a chair in the room of, or the intruder sat down in a chair. Again, those things, I mean, the injuries weren't described, obviously, to that extent in the PCA. So that one, you probably have something. Maybe you shouldn't have said that. Now, the other thing are the pictures, the selfies. Again, those selfies and the searches, the Ted Bundy searches and whatnot. Now, the searches were for Ted Bundy that they talked about. They talked about the music choices. They talked about videos that he was watching. It never once said that he searched Maddy Mogen, Kaylee Goncalves, Xana Kernodle. None of those folks, right? Those weren't part of those searches. So in the end, what is it that is different from what was public? Phone calls with dad, some of the injury descriptions to one of the victims, and some pictures, some selfie pictures that he took. Now, is it possible he posted those selfie pictures somewhere? Maybe on a public site, maybe his Instagram, maybe his Facebook, maybe something that's been taken down that we don't know about now, but was in a public place before that the Wayback Machine could find or something. I don't know. I don't know the answers to those questions. But again, most of the stuff that they said is on court documents. They may have added some music like Ann Taylor said and done those type of things, but they really didn't do anything crazy. So in the end, do I think that they're going to get this continuation? I think it's going to get denied. I am about 75% sure it's going to get denied. Now, because the defense whines so much, maybe they'll get, the continuation. I hope it don't go through, but my prediction is that it'll get denied. All right, I'm going to answer a few questions before calling it a show. Let's see. Everything Ann Taylor is arguing comes after BK was convicted. She is saying he's guilty, and all of the things she's asked for, she's already gets per federal law. It is dumb. Thank you so much, Mark. I appreciate that. I agree with what you're saying. I agree. Loaded Hot comes in $2, says he sure didn't go hungry as a child. That's true. That was one of the things, right? That he was overweight. So he wasn't malnourished. He wasn't neglected. That's a good point, Loaded Hot. Thank you so much. Balance Freedom, $9.99. How concerned is everyone that there may be a delay related to the Dateline issue? I saw Daniel's recent discussion with Jen Coffindaffer and her tape. Makes me nervous. I think he's pissed. He's upset. Obviously, Judge Hippler's upset, and he wants to find out if somebody had something to do with this. But that has nothing to do. That's just a completely separate situation, right? It sounds like whoever did it is going to be prosecuted or could be prosecuted for doing it, for violating the gag order. And so that's a complete separate issue on its own. So I don't think it would have an effect to a certain extent. Now, I think that her arguing the fact that they haven't gone through evidence probably holds more water for a delay than the Dateline stuff. Like if it was just the Dateline thing, I would be like 95% certain that this is going to go forward. It's not the Dateline stuff. It's all this other stuff that they're trying to throw out there, red flags and mitigation things that they want to uncover and do all these things that has me worried about the continuation more so than the Dateline. Great question. Great question. Sounds good, Heather. Thank you so much. Let's see. Do you think the secret hearing help or just hurt public's right to know? Public courtroom, private secret hearings. The current secret hearing, the one about the victim's role, no, not at all. That's something completely separate. I think that has to do with like victim impact statements and things of that nature. So I don't think that has anything to do with it. Wondering alternative perpetrators. Yeah. It sounds like in the documents that they don't have all the information for that. When will we find out if there will be a delay? That's a good question. I'm not sure. But as soon as I find out, I'll let you guys know. As you guys know, I do typically get information like that ahead of time. And Taylor was waiting for this chance to beg for another delay. Does this really violate BK's rights? What about the rights of Kaylee, Maddie, Xana, Ethan, and their families? I think it's just a tactic, just like the appeal stuff. Once he's found guilty, they're going to file for appeal. The Kohbergers and whatnot are going to jump up and say, oh, he's going to get an appeal. They filed it. So we know that he's going to win it. He's not. Daniel, who do you think and Taylor is going to name as an alternate suspect? I don't know. Hopefully nobody. I'm hoping that nobody's name gets drugged into the mud. How much extra time is she asking for? She don't put it. That was one of the things as well. She doesn't put on here how many days that she wants. Just kind of saying that, well, once we do the background history on everybody, then we'll know which experts we need. And then after that, we'll know more or less how much more time we'll need. Is kind of what they said. And so I think that's when I said, if it were up to the defense, we'd probably be looking at 2 years down the road, which is an interesting thing for somebody that is supposedly innocent, right? An interesting thing for somebody to stay in jail for 4, 5, 6 years on their own, for their own reasoning. Like it's not because the prosecution is dragging their feet. It's because they want to delay and prolong it. It's an interesting tactic for somebody claiming to be innocent. Any chance of the phone being suppressed? Highly doubt it. I don't think anything's getting suppressed. If the defense was aware of the evidence, how can they delay? It's been 3 years to prepare. That's what the judge said too. Is there getting any hearing of these? Is there going to be a hearing on these docs, or was this already one? I've been keeping up for a few days. I don't think there's going to be a hearing on this. I think there's just going to be a ruling. Daniel, do you know the Dateline source? Just curious. Well, I'll say this. I don't know. I don't know for sure. I'd say that Howard Bloom was really, really on there. So I wouldn't be surprised if some of the sources may have been from Bloom sources. I think that when it comes to suspect vehicle 1, I wouldn't be surprised if they went out there and spoke directly to the source of who owned that footage way before the non-dissemination order was in effect. I would assume that. I think they spoke to a lot of people in person, a lot of students and stuff, which aren't a part of the non-dissemination order. You know what I'm saying? So I don't know who they are, but trying to deduce it, I would guesstimate. If I had to take a guess, I'd say an FBI agent. And I doubt that the FBI is gonna bow down to a state court and divulge anything. So I don't think it's gonna go anywhere. But if I had to take a guess, I would say an FBI agent. Wasn't it just a few hearings ago when Ann Taylor requested the state not bring up BK's past and demanded certain words be banned? Now she's asking for everything. We better tell her to jump off. Good one, K-Bird. I like that. I like that. Now, let me just run through this real quick. All right. Psychic Daniel. You know it. I predicted a lot. You know why? Yeah. The only reason I say I'm Psychic Daniel, and just in full disclosure, be the last thing I say, is because I've gotten a lot of things right about a lot of this stuff, and a lot of it's just been deducing what Ann Taylor has said, her court filings and stuff, what she's brought out. I've been able to read what she says and read between the lines and kind of deduce what's going to happen. There's no psychicness about it, but I get a lot of people that feel like kind of say that I don't know what I'm talking about. And so if I don't know what I'm talking about and I keep getting things right, then it must be because I'm psychic. And so it's a joke. I'm not psychic. So when you hear Psychic Daniel or anything like that, I'm not psychic. I've only been able to predict some of the things that are happening because it's pretty easy to follow what they're doing, in my opinion. The only thing that I will say is when I predicted that he was listening to Britney Spears, that was a joke. I had no inside information on that he was a Britney fan. Did not know. It was the wrong song. I said he was listening to Not Yet a Woman by Britney Spears and ended up being Criminal by Britney Spears. But that was a joke. And no problem, no powers there. But I want to thank everybody for tuning in. If something breaks tomorrow, I'll be on tomorrow. If not, then I probably won't be back until Friday. But thank you guys. Thank you, mods. Thank you, members. If you're a new member, check out the community post. I'm going to put a link in the community post for our Discord. So until next time, guys, we'll see y'all later. Peace.